Right, I'll proceed the sentence. Thank you. Stephen Mitzi and Donovan Rodriguez, you've each been found guilty by a jury of one charge of imported commercial quantity of border-controlled drugs, contrary to section 307.11 of the Criminal Code Commonwealth, which carries a maximum penalty of imprisonment for life. You both come before the court with no prior criminal history. A document entitled Brief Overview of Facts for Sentence was tendered on the plea. In my opinion, that document is consistent with the verdicts of the jury and may be summarised as follows. Stephen Mitzi, you were born in 1982 and were aged 36 at the time of the offending. Donovan Rodriguez, you were born in 1981 and were aged 37 years at the time of the offending. Your co-offender, Alicia Mason, was aged 37 years at the time of the offending. On 14 December 2022, I sentenced Miss Mason for her role in the offending. Miss Mason pleaded guilty to one charge of importing a commercial quantity of a border-controlled drug, contrary to section 307.11 of the Criminal Code, and one charge of contravening a conduct condition of bail, contrary to section 30 capital A of the Bail Act 1977. Miss Mason was sentenced to 11 years imprisonment with a non-parole period of 7 years. In the sentencing remarks, I indicated that but for the plea of guilty and Miss Mason's undertaking to cooperate with the authorities, the head sentence would have been 29 years. I turn to the circumstances of the offending. Along with Miss Mason, each of you engaged in conduct which constituted the importation of a consignment containing about 1,280.6 kilograms of pure methamphetamine and about 29.5 kilograms of pure heroin. The consignment arrived in Melbourne by sea from Thailand on 30 March 2019. The offending arose in the course of each of you participating in an ongoing agreement with each other, Miss Mason, and unknown others to import a number of consignments. Between December 2016 and April 2019, 7 consignments were imported pursuant to that agreement. It is not alleged that you, Donovan Rodriguez, were involved in the importation of the first consignment. The contents of the first 6 consignments are unknown. The 7th consignment contained the border-controlled drugs, which are the subject of the charges the jury has found proven. The methodology used to import the consignments was consistently characterised by the use of a false consignee for the imported goods, the creation and use of false documents to facilitate the importation, and the collection and the delivery of the consignments to unknown locations, but for the final consignment, the subject of the charges. Between 3 December 2016 and 15 October 2018, 6 consignments were imported into Australia by you, Stephen Mitzi, and Alicia Mason. You, Donovan Rodriguez, were involved in all of the importations, save for the first one. The methodology employed was designed to conceal the true identity of the people responsible for the importation. A, Miss Mason used her existing, otherwise legitimate businesses to communicate with the shipper, ECU. B, you, Stephen Mitzi, operated false email addresses, made or arranged payments to ECU, and created false documents on behalf of the ostensible consignees, concealing your involvement by using a virtual private network and cryptocurrency. And C, you, Donovan Rodriguez, use your otherwise legitimate business, D Corp Proprietary Limited, to collect all but one of the consignments under bond and then delivered them to unauthorised destinations. For Synergy Consignments 3, 4 and 5 and the CPL consignment, D Corp issued invoices to the ostensible consignee for services purportedly rendered in respect of those consignments. The invoices related to the CPL consignment and Synergy Consignment 4 were paid by unknown persons using cryptocurrency into a D Corp bank account controlled by you, Donovan Rodriguez, totalling $11,456.83. Additionally, shortly after the deliveries of Synergy Consignments 2, 3 and 4, Cash deposits totaling $112,750 were made into bank accounts held by you, Donovan Rodriguez. That money was payment for your role in the importations. The charges relate to the importation of a consignment which arrived in Melbourne by sea on 30 March 2019, which was referred to in the trial as Synergy Consignment 6. It was shipped by BKK Sound System Company Limited to Synergy Audio Visual Proprietary Limited and was declared to contain 6 pallets or 72 cartons containing speakers with a gross weight of 2,314.8 kilograms. Synergy is a real company which did not in fact order or import the consignments. It was used as a front consignee for Synergy Consignment 6 and 5 previous consignments which were imported pursuant to the ongoing agreement. Both prior to the arrival of Synergy Consignment 6 and after it had arrived in Australia on 30 March 2019, Ms Mason, together with you, Stephen Mitzi, communicated by licit and illicit, that is, concealed or encrypted means. You and Ms Mason also met to discuss the consignment. Between 18 March 2019 and 4 April 2019, you, Stephen Mitzi, imported the border-controlled drugs which were contained in Synergy Consignment 6 by A, on 18 and 26 March 2019, using an email address falsely purporting to be associated with Synergy to send emails to Ms Mason, attaching shipping documentation regarding Synergy Consignment 6. B, on 29 March 2019, using the false Synergy email address to send an email to ECU saying that you would send a remittance through shortly in respect of ECU's involvement for its shipping fees. C, on about 30 March 2019, making or arranging to be made a cash deposit of $3,953.81 into a bank account held by ECU in payment of ECU's invoice. D, on 2 April 2019, using the false Synergy email address to send an email to ECU, attaching a false remittance advice in respect of the payment of ECU's invoice, which was a remittance advice purporting to be from Synergy, but had in fact been created by you. E, on 3 April 2019, using the false Synergy email address to send the delivery order to Ms Mason. And F, on 3 or 4 April 2019, providing Ms Mason with a mobile number which you had purchased and falsely subscribed in the name of Renato Trenton on 3 April 2019, being a number which Ms Mason subsequently provided to Cargo Port as a contact number for the consignee. On 4 April 2019, you, Donovan Rodriguez, imported the border-controlled drugs which were contained in Synergy Consignment 6 by A at 12:30 p.m. on 4 April 2019, using internet banking to make a payment of $461.58 to Cargo Port in respect of its fees regarding Synergy Consignment 6, and B, at 12:36 p.m. on 4 April 2019, sending an email to Cargo Port purporting to be Ms Mason, attaching a receipt for the payment made regarding Synergy Consignment 6. On 5 April 2019, you, Donovan Rodriguez, hired a truck and attended Tasman Logistics in order to collect the consignment. You were unable to do so because the consignment had not been cleared. Intercepted communications revealed that over the following days, Ms Mason and you, Donovan Rodriguez, in consultation with you, Stephen Mitzi, waited to see if the consignment would be cleared. However, on 5 April 2019, the consignment had been taken from Tasman Logistics to an Australian Border Force examination facility. It was examined by Border Force. It was found to contain methamphetamine and heroin concealed within speakers. Methamphetamine and heroin are each border-controlled drugs. A commercial quantity of methamphetamine is 0.75 kilograms or more. A commercial quantity of heroin is 1.5 kilograms or more. The contents of the consignment were analysed. It was found to contain 1,596,123.5 grams, that is approximately 1.6 tonnes of methamphetamine with a purity of between 80.1% and 80.3%. It was also found to contain 37,184.6 grams, that is approximately 37 kilograms of heroin, with a purity between 76.5% and 79.9%. The total net weights of pure methamphetamine and heroin, respectively, were A, methamphetamine, 1,280,586.9 grams, about 1,280.6 kilograms, and B, heroin, 29,450.1 grams, about 29.5 kilograms. The amount of methamphetamine in the consignment could generate 15,961,235 individual doses. It is estimated that A, the wholesale value, if sold per kilogram, was between $119,709,000 and $191,534,400, and B, the street value, if sold per gram, was between $287,302,230 and $638,449,400. The amount of heroin in the consignment could generate 1,487,384 individual doses. It is estimated that A, the wholesale value, if sold per kilogram, was between $6,134,700 and $7,250,100, and B, the street level value, if sold per gram, was between $29,747,680 million and $59,495,360. On 9 April 2019, the consignment, excluding the border-controlled drugs, was repacked by the Australian Federal Police. A controlled operation was commenced and the consignment was returned to Tasman Logistics and cleared. Cargo Port advised Ms Mason that the consignment was available for her collection. However, notwithstanding the early arrangements made to collect the consignment, including hiring the truck, and the fact that on 9 April 2019, the D-Corp invoice reportedly issued to Synergy in respect of Synergy Consignment 6 had been paid by way of a cash deposit of $8,689.57 into a bank account held by you, Donovan Rodriguez. You and Ms Mason did not make any further attempt to collect the consignment from Tasman Logistics. Thereafter, A, after learning that the consignment had been held by the Australian Border Force, the three of you jointly decided to not collect it and to distance yourselves from the consignment. B, Ms Mason, in consultation with you both, sent emails to Cargo Port and the false Synergy email address operated by you, Stephen Mitzi, and communicated with an undercover operative purporting to represent Tasman Logistics in order to create the appearance of an innocent justification for the non-collection. You, Donovan Rodriguez, also sent one such email. And C, intercepted communications between Ms Mason and you, Donovan Rodriguez, revealed that you, Stephen Mitzi, were consulted in relation to your conduct in distancing yourselves from the consignment. On 7 June 2019, Ms Mason and you, Donovan Rodriguez, saw an AFP media release about the interception of the consignment. Your responses indicate that you both knew that the consignment with which you had dealt with contained drugs. You, Donovan Rodriguez, referred to you, Stephen Mitzi, giving you and Ms Mason a, quote, crap pay rise. And Ms Mason said, quote, that one was going to be more, Donnie, indicating an expectation of reward. On 13 June 2019, after receiving a call from police, Ms Mason and you, Donovan Rodriguez, discussed aspects of the false accounts you would give to avoid being charged and prosecuted, including inquiries to be made of you, Stephen Mitzi, as to what you could say. Alicia Mason gave evidence at trial to the effect that she jointly imported the consignments, including Synergy Consignment 6, with you, Stephen Mitzi, and except for the first consignment, you, Donovan Rodriguez. Amongst other things, she gave the following unchallenged evidence. A, She recruited you, Donovan Rodriguez, before the second consignment. She told you that Stephen Mitzi had asked her to do some deliveries for him and that she thought they were, quote, shifty. You asked her if they were drugs, and she said she did not think so. You agreed and told her to let you know when they came in and you would do the delivery. B, after you delivered Synergy Consignment 2, you told Miss Mason that the people who met you had checked the cargo using scanners before you were allowed to leave. C, when Miss Mason had a shipment, she would tell you that you had to be available to deliver it and that you would make yourself available to do it. You picked them up and delivered them to another address, which was given to you by Miss Mason, which was given to Miss Mason by you, Stephen Mitzi. D, Miss Mason and you, Donovan Rodriguez, had, quote, very vague discussions about what you both thought might be in the consignments and that they could contain drugs. Between Synergy Consignments 4 and 5, you and Miss Mason had a conversation, quote, thinking that it might be drugs. E, after Synergy Consignment 5, Miss Mason realised that ECU were asking questions about the underbond movements, and she told you, Stephen Mitzi, that you could not keep importing the consignments. You told her that it was too late. Synergy Consignment was on the water, and she needed to do it because, quote, they know who you are, they know who your family is, end quote. During that conversation, Miss Mason asked if there were drugs in the consignment, and you told her not to ask questions. F, Miss Mason told you, Donovan Rodriguez, when Synergy Consignment 6 came in. She asked you to pay the cargo port invoice and send the remittance to cargo port so they knew the charges had been paid. G, you, Donovan Rodriguez, and Miss Mason rented a truck to pick up the consignment. You told Miss Mason what truck you needed in order to pick up the consignment. H, before the consignment came back to Tasman Logistics, you and Miss Mason decided to leave it. She discussed with both of you what to do if questions were asked about the consignment, and you all agreed to say that Synergy had not contacted you, and I, Miss Mason, met you, Stephen Mitzi, sometime later at your office to give the cipher phone back to you. You talked about another shipment that was going to come in. You gave her an envelope to hold, which contained a SIM card and a driver licence. Both of you and Ms Mason were arrested on 4 December 2019. Search warrants were executed at various locations. A number of computers and telecommunications devices were located. So too were documentary records, including real identification documents pertaining to other people, including some which had been used to facilitate the importations. Analysis of bank accounts controlled by you, Stephen Mitzi, revealed the following. A, between 1 July 2016 and 30 June 2019, the largest source of funds into your personal bank account was 39 cash deposits, none over $10,000, totalling $210,702. B, during the same period, 60 cash deposits, none over $10,000, totalling $317,025, were made into a bank account held by your business and controlled by you. And C, a comparison with your personal and business tax returns showed that the difference between the declared income and the total income actually received was approximately the same as the cash deposits. The cash deposits made into your personal and business accounts were the proceeds of or payment for your role in the importations. On 4 December 2019, you, Stephen Mitzi, participated in a record of interview with police. You denied any involvement in the offending. Your account was false. You, Stephen Mitzi, gave evidence in your trial. While you admitted telling some lies to police in your record of interview, you again denied any involvement in the offending. By its verdict, the jury rejected your exculpatory account beyond reasonable doubt. On 4 December 2019, you, Donovan Rodriguez, participated in a record of interview with police. You made some admissions, including that you paid the cargo port invoice relating to Synergy Consignment 6 on 4 April 2019, but gave a false account of your involvement in the importation of that consignment and the earlier consignments. Your account contained lies which were told to conceal the true nature of your involvement and knowledge of the consignments, and specifically Synergy Consignment 6. Your account also contained lies as to the source of the cash deposits made into your bank accounts following your delivery of Synergy Consignments 2, 3 and 4. Between December 2020 and March 2021, while you, Donovan Rodriguez, were in custody and Miss Mason was on bail, you communicated with each other by telephone in breach of her bail. During the calls, you pressured Miss Mason to change those parts of her statement which inculpated you and encouraged her to give evidence which was different to that in her statement. I turn to the nature and gravity of the offending. The charge to which each of you have been found guilty by jury is inherently a very serious offence, which is reflected in the maximum penalty of life imprisonment. In the New South Wales decision of the Queen and Nguyen and Pham, the Court of Criminal Appeal distilled from the authorities a number of propositions applicable to sentencing for drug importation offences. These propositions have been cited with approval in the Victorian Court of Appeal by the Victorian Court of Appeal in Nguyen and Pommelsack and the Queen, where President Maxwell stated that the propositions substantially accord with the course of decisions in Victoria. Those propositions, which I have taken into account in assessing the gravity of your offending, are as follows. 1, the criminality of an offender must be assessed by consideration of the involvement of the offender in the steps taken to effect the importation. Where it is capable of being discerned, the role played by the offender is of great importance in assessing the objective criminality of the offence. 2, problems may emerge when a sentencing court attempts to categorise the role of the offender in the drug enterprise, as in many cases the full nature and extent of the enterprise is unlikely to be known to the court. 3, it is the criminality involved in the importation which must be identified. The fact that another person may be characterised as the mastermind does not mean that a person who is responsible for managing the importation into Australia is properly described as having only a middle level of responsibility. 4, although the weight of the drug imported is not the principal factor to be considered when fixing sentence, the size of the importation is a relevant factor and has increased significance when the offender is aware of the amount of drugs imported. 5, ordinarily the amount of drug involved in importation is a highly relevant factor in determining the objective seriousness of the offence, even to the extent of assessing that the particular offence is in the worst category of its type. In many cases, the only factor that would lead to a determination that one importation is worse than another would be the amount of drug involved, where otherwise the circumstances of the importation were the same or very similar. 6, as a matter of common sense, it should be inferred, unless there is evidence to the contrary, that a person who is importing drugs is doing so for profit. The fact that the offender needs money to pay off a debt does not necessarily affect culpability. 7, the difficulty of detecting importation offences and the great social consequences that follow suggest that deterrence is to be given chief weight on sentence and that stern punishment will be warranted in almost every case. 8, the sentence to be imposed for a drug importation offence must signal to would-be drug traffickers that the potential financial rewards to be gained from such activities are neutralised by the risk of severe punishment. 9, involvement at any level in a drug importation offence must necessarily attract a significant sentence. Otherwise, the interests of general deterrence are not served. 10, the prior good character of a person involved in a drug importation offence is generally to be given less weight as a mitigating factor than it might otherwise be given. And 11, where the offenders are not young, the immaturity of youth cannot be claimed as a factor bearing upon their transgressions. The quality of drugs you both imported was substantial and valuable. Synergy Consignment 6 contained almost 1.6 tonnes of methamphetamine and just over 37 kilograms of heroin, in each case with a purity of approximately 80%. The methamphetamine was more than 1,700 times the commercial quantity of methamphetamine, while the heroin was more than 19 times the commercial quantity of heroin. Translated in pure form, you imported 1,280 kilograms of pure methamphetamine and 29.5 kilograms of pure heroin. While the street value of each drug combined at the time of investigation was estimated to be $697.8 million, what is perhaps more disturbing is the estimated individual doses that could be generated. Almost 16 million doses of methamphetamine and almost 1.5 million doses of heroin. Plainly enough, the drugs that you imported had the potential of wreaking enormous harm on individuals, families, and the wider community. Turning to the role each of you played in the importation. Stephen Mitzi, your offending relates to your conduct between 18 March 2019 and 4 April 2019. While by its verdict, the jury found that you were at least reckless that the substance in Synergy Consignment 6 was border-controlled drugs, the prosecution submit that the court can be satisfied that you in fact knew that the substance was border-controlled drugs. In support of this contention, the prosecution points to the evidence that defines your role in the enterprise, including A, your role in the offending, much of which can be inferred from the conversations you had with Ms. Mason, B, the fact that you received and conveyed documents that contained information as to the size and weight of the consignment, C, your efforts to conceal your involvement in the offending, particularly after the consignment had been intercepted, D, your provision of shipping documentation and information to Ms. Mason by covert means, including the making or arranging payment of ECU fees, providing false remittance advice, and falsely subscribing a mobile phone number, E, the fact that you're involved in the importation of 7 consignments over 2 years using a similar methodology, F, your use of encrypted communications on BlackBerry and Cypher devices and the use of virtual private networks, G, the fact that you are the link to the unknown criminal network where you obtained information in relation to the importations that was passed on to Ms. Mason, H, that you recruited Ms. Mason and ultimately threatened her in relation to Synergy Consignment 6, and that you spoke with Ms. Mason in relation to proposed further importations, and I, your reward, which in relation to Synergy Consignment 6 is unknown but can be inferred as noted at point 6 in Nguyen. The prosecution submit that it must have been commensurate with the reward you had received from the previous consignments on the evidence more than $500,000 by unexplained cash deposits over the period of the other consignments. Other importations, I should say. Considering the matters above and having heard the whole of the evidence, I am satisfied beyond reasonable doubt that you, Stephen Mitzi, knew the substance in Synergy Consignment 6 contained a large quantity of border-controlled drugs. The prosecution submit that on the evidence you were the most senior known participant in the importation and at the top of the hierarchy as between the 3 co-offenders, which I accept. Further, that you were the link to the criminal enterprise from which you received instructions that you passed on to Ms. Mason. In all the circumstances, in my view, your moral culpability can only be assessed as very high. Donovan Rodriguez, your offending relates to your conduct on 4 April 2019, as particularised in the indictment. By its verdict, the jury has found that you were at least reckless that the substance in Synergy Consignment 6 was border-controlled drugs. Prosecution concedes that there is no evidence that you knew the precise type or amount of drugs in the consignment. That said, in order to establish that you were well aware of the substantial risk that the consignment contained drugs, the prosecution point to the conversations you had with Ms. Mason, the circumstances of your involvement in delivering the previous consignments, and the steps you and Ms. Mason took after becoming aware of the interception of Synergy Consignment 6. It is plain that by its verdict, having heard and considered the whole of the evidence, the jury was satisfied that you were well aware of a real or significant chance that the substance was concealed within the consignment, and that you must have been aware of a substantial risk that the substance imported was border-controlled drugs. Turning to your role, Mr. Rattray, who appeared on your behalf, submitted that your conduct should be limited to the 2 particulars in the indictment and therefore should be viewed as, quote, trivial and at the lowest conceivable end of the offence, unquote. As such, he takes issue with the prosecution contention that your guilt arose in the context of your participation over several years in an ongoing agreement with Stephen Mitzi and Ms. Mason to import consignments, and that you knew, at the very least, from Synergy Consignment 2 onwards, contained something illegal or, quote, shifty, as evidence from your ongoing conversations with Ms Mason around the time of the second consignment. By way of example, in Ms Mason's evidence, when being questioned about the conversations she had with you as to the content of the consignments, the evidence is as follows. Question: did you and Mr Rodriguez have any other discussions about the consignments? Answer: we had very vague discussions, sometimes about what we may think might be in the containers. Question: so what do you recall of those conversations? Answer: that it could contain drugs. Question: and did you express that belief to Mr Rodriguez that it might contain drugs? Answer: yes, but it's yes, we spoke about that it could contain drugs, but we never knew exactly. It's just what we were thinking. More particularly, the prosecution submit that your role and culpability must be assessed against the backdrop of the agreement, including A, that you had collected 5 previous consignments and attempted to collect Synergy Consignment 6. B, that you had delivered Synergy Consignments 2, 3, 4 and 5 to unknown locations. C, that after the second, third and fourth Synergy consignments, large cash deposits were made into your personal bank account. And D, that you delivered several consignments to unknown locations and observed the precautions taken by the syndicate to avoid detection, including scanning the delivery. As to any reward, as noted above in relation to your co-offender, Stephen Mitzi, it is able to be inferred that you were motivated by financial gain. Of the false D Corp invoices issued, 3 were paid into accounts controlled by you, totalling $20,146, Synergy Consignments 4 and 6 and the CPL consignment. As to Synergy Consignments 2, 3 and 4, additional cash deposits above the invoiced amounts, totalling $112,750, were made into your bank accounts, and I'm satisfied that these deposits were related to your involvement in the identified earlier consignments. In a recorded conversation on 7 June 2019, after seeing the AFP media release, you and Ms Mason made comments suggesting that further award was expected in relation to Synergy Consignment 6. You said, quote, I think Stephen's given us a crap pay rise. Ms Mason later says, quote, I would have loved that money. That would have solved everything, yeah? And, quote, that one was going to be more, Donnie. While the exact reward that you were to receive from your involvement in Synergy Consignment 6 is uncertain, having considered the circumstantial evidence led at trial, including the cash deposits made into your accounts in close proximity to your delivery of Synergy Consignments 2, 3 and 4, I am satisfied that your reward was to be more than the amount you received in relation to the false invoices. Turning to hierarchy. As to the hierarchy of offending between the two of you and Ms Mason, the prosecution submits that the role you, Stephen Mitzi, played was above that of Ms Mason, which is plain on an analysis of the whole of the evidence and your specific role as I have detailed above. As to you, Donovan Rodriguez, based on the evidence and the particulars of the indictment, your role is much more discreet, as particularised and somewhat lower than that of Ms Mason. What is common between the three of you is that you all imported the same amount of border-controlled drugs. I turn to personal circumstances. Stephen Mitzi, you were born in 1982 and you're currently 42. You were born in Footscray and raised in Deer Park. You're the middle brother in a sibship of 3 boys. Both of your parents were born in Malta and immigrated to Australia prior to the birth of your older brother. They remained married. You grew up in a stable and supportive family environment and enjoy the continued support of your parents and siblings. Your mother remained at home during your childhood and had a significant role in caring for you and your siblings before obtaining a position as a medical receptionist when you were in secondary school. Your father worked long hours as a chief financial officer in various multinational companies. Your family did well financially, and you recall that many school holidays and weekends would be spent at the beach in Torquay. You also travelled overseas with your family. You were encouraged by your parents to socialise and participated in many sports, reporting that there were no particular restrictions placed on what you were able to do. Your parents' relationship was very positive, and you do not recall them having any significant arguments. You would attend weekly Mass with your family and undertook the traditional rites of the Catholic Church. You were close with your brothers growing up. However, you have become more distant with your older brother since he relocated to the United Kingdom. You had a positive schooling experience and completed Year 12 at Salesian College, reporting you related well to your teachers and peers. You subsequently completed a Bachelor of Computer Science in 2002 and gained employment in the information technology sector through a biomedical company. At the age of 26, you went on to establish and run your own business in the information technology sector, where you focused primarily on corporate clients. Tendered on the plea was a psychological report prepared by consultant psychologist Warren Simmons, dated 8 October 2022, in which you report that despite sleep disturbances, your mental health has been stable throughout your life. Mr. Simmons further details that you do not suffer from any significant psychiatric disturbance, nor show evidence of any significant antisocial personality. Your personal relationships reflect this stability, as you have been in 3 significant long-term relationships. You're engaged to your last partner, however, you are no longer together. You detail that the cause of this breakup was due to incompatibility rather than any significant dysfunction or interpersonal conflict. You were introduced to alcohol in high school and you drank occasionally on the weekends in social settings with friends. However, your consumption increased upon completing university. You submit that by the age of 21, you're consuming around 1/3 of a bottle of whiskey every night, which escalated to a full bottle over the next 15 years. You're consequently given a withdrawal pack containing Valium to avoid withdrawal complications when initially placed into custody. Your drug use followed your alcohol consumption, and you commenced snorting cocaine in your late 20s, increasing to daily use. Your drug use reached its pinnacle between the ages of 35 and 37, where you report having between 2 or 3 lines a night. You acknowledge that at this time, you're also drinking too much, resulting in poor liver function and hypertension. Both of these conditions have improved since you have been in custody. Character evidence was relied on at trial, attesting to your good nature, which was then formally tendered on the plea. A collection of friends and family, each of whom have known you for a considerable amount of time, gave evidence at your trial referencing you as a person of good character, one who is loyal and trustworthy. You have remained in contact with each of these witnesses throughout your period in custody. Your sister-in-law, with whom you have known, whom you have known for 30 years, for approximately 30 years, further speaks to your character and reputation, detailing your integrity and hardworking nature. She noted your commitment and loyalty to your friends and family. Additionally, she detailed the relationship you have with her children, your niece and nephew, stating she could rely on you to babysit or help with school drop-offs. Moreover, she describes the father figure relationship you had with her ex-partner's daughter, continuing the relationship even after your relationship with her mother had ended. It is clear from these references that your family remains supportive of you. Donovan Rodriguez. You were born in 1981 and are now 43 years old. You are the oldest child of a sibship of 3. Your parents immigrated to Australia from India in the late 1970s. You have been supported by your family throughout the entirety of these proceedings. Following school, you undertook a mechanics apprenticeship. Since finishing school, you have maintained consistent work, including as a mechanic for 5 years and then working as an employee at your father's company, D Corp Proprietary Limited. You later became the sole director of the company. When you were remanded in December 2019, you endured onerous conditions whilst in custody, including being held in near total isolation, which I will detail further below. Upon your release on bail in May 2023, you returned to full-time work at D Corp, supervised by your father. Following the trial, you were remanded on 16 May 2024 and report that your conditions in custody have improved. A letter from your father, Dudley Rodriguez, was tendered on the plea and details the devastation and disruption this offending has caused your family. Your father notes that since the offending, the health of both your parents has declined and that they are no longer in a position to work for the family business. It is acknowledged that your parents were in attendance throughout the trial and despite the impact of the offending has had on their lives, remain supportive of you. Character evidence was relied on at trial, attesting to your good nature, which was then formally tendered on the plea. The character evidence details your hardworking and trustworthy nature. I turn to sentencing considerations. As charges 1 and 2 are Commonwealth charges, I am required to sentence each of you in accordance with Part 1, Capital B of the Crimes Act 1914. Pursuant to Section 16, Capital A1 of the Crimes Act, the overarching principle is that any sentence I impose must be of a severity appropriate in all the circumstances of the offence. As part of that process, I must take into account the non-exhaustive list of matters pursuant to Section 16, Capital A2 of the Crimes Act that are relevant and known to the court. Turning first to matters in mitigation. The offending concluded, and firstly, procedural history and delay. The offending concluded in April 2019. You were each arrested on 4 December 2019. Ms Mason made her respective statements on 18 May 2020 and 3 September 2020. In early 2023, pre-trial argument commenced before a different judge in this court. Following arguments in relation to prosecution disclosure, the matter was adjourned in order for further materials to be disclosed and provided to defence. As a result of the delay, bail was granted to you, Stephen Mitzi, on 24 May 2023, and to you, Donovan Rodriguez, on 25 May 2023. Some further delay was caused as a result of you, Stephen Mitzi, changing your barrister during the pre-trial period. Following pre-trial argument and then pre-recording of Ms Mason's evidence, a jury was impanelled on 4 March 2024. The trial ran for some 11 weeks, the jury returning verdicts of guilty on 16 May 2024. A plea date was set. However, further delays followed as a result of funding issues in relation to you, Stephen Mitzi. The plea was ultimately conducted on 10 October 2024, with time being granted to you, Stephen Mitzi, to file further submissions following the hearing. Ultimately, no further submissions were filed. On any view, the delay has been lengthy, and apart from a change of counsel and funding concerns in relation to you, Stephen Mitzi, the delay is not attributable to either of you. I take this delay into account in the sentencing discretion, as this is a serious matter that has been hanging over your heads for a considerable period of time, causing great uncertainty and anxiety to you both. A large proportion of the time you both have spent on remand was subject to COVID restrictions, resulting in periods of lockdown and isolation and limitations to support services and programs. I take these matters into account. Further, in relation to you, Donovan Rodriguez, for reasons that have not been explained, from March 2021 until your release on bail on 25 May 2023, you were kept and transported under harsh conditions. During this time, you were held in a management unit in isolation, and when transported to court, you were subject to handcuffs and leg chains. I take these matters into account. Turning to your prospects of rehabilitation. You both come before the court with no prior criminal history. You both also enjoy the ongoing support of your respective families. While in cases such as this, good character is of less weight on the evidence, it appears that the prospects of rehabilitation in relation to each of you can be assessed as at least very good. Turning to other sentencing considerations. As is well established in cases of large drug importations, general deterrence is the paramount sentencing consideration. At the time of the interception, the methamphetamine you imported amounted to one of the largest importations of methamphetamine in Australia. The amount of heroin was also substantial. Offending such as yours is difficult to detect, and the great social consequences that flow from the commission of such offending is significant. As noted in Nguyen at Propositions 8 and 9, the sentence to be imposed must signal to would-be drug traffickers that the involvement at any level in a drug importation offence must necessarily attract a significant sentence. Otherwise, the interests of general deterrence are not served. The prosecution provided a table of comparative cases which I have taken into account. Ultimately, Mr Isle KC, who appeared with Mr Kex on behalf of the Commonwealth Director of Public Prosecutions, submitted that the best comparator is the sentence of Ms Mason, which was upheld following appellate review. Miss Mason pleaded guilty and gave evidence at the trial pursuant to her undertaking. As such, while she falls in the middle of the hierarchy, her sentence was also subject to significant discounts, together with other mitigating factors that are absent in relation to each of you. Of the table of cases provided by the prosecution, it was submitted that the quantity of drugs imported is greater than any of the cited cases. Of those cases, in terms of quantity, the closest is Thompson and the Queen, where the offender imported 1.11 tonnes of pure cocaine. The Crown case at trial was that the offender participated in a single conspiracy, which involved 3 separate attempts to import a border-controlled drug into Australia. The first 2 attempts failed. On the 3rd attempt, the offender and a co-conspirator departed New Zealand on a yacht owned by the offender. They rendezvoused with a mothership in international waters from which cocaine was transferred on board. Thompson was described as a principal and was sentenced to life imprisonment with a non-parole period of 22 years. His appeal against conviction and sentence was dismissed. Geraghty and the Queen, the offender was a co-offender of Thompson and was also found guilty at trial. Geraghty was considered to be higher in the hierarchy than Thompson. His role was described as paramount, and he recruited the other co-conspirators. As he recruited the other co-conspirators, oversaw their roles in the operation. Geraghty had prior convictions for importing drugs. He was sentenced to life imprisonment with a non-parole period of 25 years. As noted, I have read and considered all of the comparative cases provided. However, each case must turn on its own facts. As was observed in Liu and the Queen, quote, ordinarily comparable cases are relevant to indicate or reveal the sentencing range for the offence which is under consideration. In that way, an analysis of comparable cases is directed to promoting consistency of sentences. However, ultimately, the consistency that is sought to be achieved is not some mathematical or numerical equivalence of sentences. Rather, the process is directed to achieving consistency in the application of relevant legal principles. For that reason, so-called comparable cases are not precedents. In the context of sentencing, no 2 cases can be alike. The factors that inform the sentence, the exercise of the discretion in each case, and the weight to be attributed to those factors vary significantly in determining the sentence that is ultimately the product of the instinctive synthesis of the sentencing judge. Mr. Mitzi, would you please stand? Stephen Mitzi, on charge 1, importing a commercial quantity of border-controlled drugs. You are convicted and sentenced to 32 years imprisonment. I direct that you serve 21 years before becoming eligible for parole. I declare that 1,484 days be reckoned as the period of imprisonment already served under the sentence I've imposed. That does not include today. Thank you. You can have a seat. Mr. Rodriguez, would you please stand? Donovan Rodriguez, on charge 2, importing a commercial quantity of border-controlled drugs. You are convicted and sentenced to 21 years imprisonment. I direct that you serve 14 years before becoming eligible for parole. I declare that 1,485 days be reckoned as the period of imprisonment already served under the sentence I have imposed. That does not include today. Thank you. You can have a seat.